This is Gerhard Volschenk speaking. I'm the Civil Principal Attorney at the Durban Local Office of Legal Aid South Africa. I've been a civil attorney for more than 25 years, and I'm now practicing with Legal Aid South Africa for the last 17 and a half years. I want to talk today about the rights of children, how Legal Aid South Africa would actually assist children, both in the criminal division as well as in the civil division. It's actually two separate legs of our law. So the criminal section is the one being organized, arranged by a certain set of rules and legislation. And then the civil section is another section also with a different set of rules and legislation. All of this, in fact, comes from the Constitution. So it's very easy if you look at it. The Constitution says every child has the right set out in Section 28 of the Constitution, and that right is and must be respected, protected, and promoted by all of us. So there's the duty that Legal Aid South Africa has. Our mandate, therefore, comes from the Constitution, and we have a duty to respect and assist all children. Let's take it first on the criminal side. Children do get into conflict with the law often, and that would then fall under the criminal division of Legal Aid South Africa. In this regard, the Child Justice Act was established to organize that position. In terms of the Child Justice Act, then, we have a duty to represent children, and it's a duty that also stems from the Constitution, and it's a duty of care and protect to the best interest of the child. So everything that happens under children's law basically boils down to the best interest principle in law. Everything we do, we must always think of the child first. So when a child comes into conflict with the law, we don't want him to sit in prison. We don't want him to be associated with hardened criminals. We don't want him to come in that section of society early on in development, because we have to look at the age and the development of a child. So if a child is, for instance, arrested on a very serious charge, we need to have a separate set of rules that apply to that child, and that will basically steer him away from prison, steer him away from hardened criminals, so that that influence at his age of maturity doesn't taint his perspective of what life is really about. So what has happened under the Child Justice Act is that a set of rules were devised whereby the child will immediately, on arrest or on incarceration, be given the services of a social worker. That social worker will then do a report for the child, which will also be his personal circumstances, of course, but will also be an assessment of the age and maturity of that child to establish whether, in fact, that child has capacity to stand trial, has capacity to understand what is happening with him. And that's an important aspect in law, your capacity. One can often state that a child knows the difference between right and wrong. And a child will answer questions and say, yes, that's wrong, I know that's wrong. But if you look deeper into the second leg of that question, it is a more complex scenario. We must always ask ourselves, if the child knows what's right or wrong, does he in fact understand when he does something that is wrong, what the repercussions and the consequences of that will bring to him? So is he of the maturity and capacity to understand the consequences of this will mean that I will have a criminal record? Often a child knows, if I lie to my mother, I'll be in trouble. But he also knows that it's not a criminal offense to lie to your mother about a minor thing. So in the same sense, when a child does something out of the ordinary, he will maybe lie about it. He will understand that it is wrong. But the second leg of that question should be, does he understand the consequences of what he is doing currently? And I often use an example to say that if you give a over full glass of water to an adult and you tell him, please put it on a table. He will put it inside the table where it wouldn't easily fall off. But when you give it to a child, he will most probably put it on the side of the table where it can easily be dropped off, or you can easily have the water spill over onto paper that's on the table, because simply put, he cannot foresee the consequences of where he put that glass. And that's the difference between a criminal intent and the capacity to understand actually what you have done. So the social worker is absolutely important to put those facts before court, and to also give the attorney insight into the personal circumstances of his client. Now, the Child Justice Act immediately, on first appearance in court, will have legal aid appointed as an attorney, as a legal representative to that client, to assist him through the process that might follow. The court will have a full report, and that report will be very valuable. Even in 3 or 4 years from now, we can get a scenario where the matter only goes to trial, and say, for instance, the co-accused in the matter are all adults, but there's one minor child. Now the magistrate will immediately have the benefit of that report, where it might state that this child is actually very young still and does not really and fully understand what happened at that point. When 3 years passes and he now appears in court, he might be a full-grown man, or she might be a full-grown person. The magistrate cannot at that point assess the capacity that was evident 3 years ago when the social worker did her review. So it's very important that children, at the first possible instance, be afforded the rights of an attorney to represent them on the first day they appear in court, to guide them through this process and to make them comfortable in the whole process. That report will then be put in front of a magistrate in what we call a preliminary inquiry into what has happened. Now, a preliminary inquiry is something that the Child Justice Act has introduced and is a must for all juveniles who get into conflict with the law. So it might be that at that stage, the magistrate says, this child is really not a criminal. This child is rather a child in need of care and protection. And we should rather divert this matter out of the criminal system, not only keep the child out of prison as such, but divert the entire matter into the civil section, where the child might be a child in need of care rather, and that the magistrate on the civil section of law then decides what is the best to deal with this child, because this child is obviously someone who has no parents, or who cannot afford to look after himself, or doesn't have the capacity to manage his own life as yet. So then the criminal law division of children's law actually intersect with the civil side of things, where a criminal magistrate in a criminal court, where the child is in conflict with law, then decides, I'm going to divert the matter not out of prison as such, not out of criminal law as such, but into the domain of the civil law, where the child now can be afforded rights and where we can look at the care and protection of the child. So instantly there you will get the overflow of children going into the civil section. Now, the civil section of children is mostly dealt with by the Child Justice Act. And we have a comprehensive and a very good Child Justice Act that gives absolute powers to magistrates in the children's court to decide what is in the best interest of the child. Whenever we look at children, we look at Section 28 of the Constitution. We say there's a duty for us to assist these children, to make sure that these children who need care and protection, that their best interests are served. And that's the question that we ask almost at every turn through the process of civil litigation. So every question that might arise in court is answered by the best interest principle. So we don't look at the best interest of the mum. We don't look at the best interest of the friends or the father. We don't look at the mother who sits in tears about what has happened to my child. We ignore that. And it can be cruel and hard sometimes to ignore that. But what we look at first and foremost is the best interest of the child only. So even if mom is crying, even if dad is crying, only the test would be, is the child satisfied, and is what is going to happen to him in his best interest. The legal representation for children then in civil matters stems from a mandate given in Section 55 of the Children's Act. And Section 55 is very clear, and it gives also an obligation and a duty to legal aid. It says where a child involved in a matter before the children's court is not represented by a legal representative, and the court is of the opinion that it would be in that child's best interest to have legal representation, the court must refer the matter to Legal Aid South Africa. It's important. It's not a choice. The Act is clear. The court must refer the matter to Legal Aid South Africa if the test can be fulfilled. The test being if it's in the best interest of the child to have legal representation. So Section 55 is very clear. It sets out the mandate for Legal Aid South Africa to assist children. But the Children's Act has gone further than any act before, in that in Section 14, the Act says, remember one thing, even if the court decides that it's in the best interest of the child, sometimes the court doesn't know about the child. I'm a 13 or 14-year-old child living with my mom and dad somewhere in town. The court will never know what is happening to this child. So Section 14 goes further and says every child now has the right to bring a matter to court on his own. Previously, a child needed to be assisted by his guardian before he could litigate in matters. But this act is very, very progressive in thinking. So what will happen now is I'm 13, I'm actually in conflict with my mother, or I'm in conflict with my caregiver, or I'm in conflict with a teacher, but I do not have the confidence to discuss that with my teacher, my father, or my mother. What do I need to do? I can go to the children's court and open proceedings to assist. The duty that kicks in on court in terms of Section 55 is then immediately this child is likely in need of care and protection, and therefore I must, as a magistrate, instruct legal aid to represent the child. So immediately that child has taken the first step, but he is also represented immediately by a legal professional who can steer him along the way. It's sometimes difficult for a magistrate, we must understand, because the magistrate cannot become involved in consultation of the child, because that's bias. At the end of the day, one of the parties will feel aggrieved and say, yeah, but how can this magistrate make rulings or decide what is good for the child without hearing us? Therefore, the magistrate refers the matter to a lawyer, and the legal aid attorney will then steer the child through. It's not then the duty of the magistrate to leave the domain of a magistrate and sort of become the child's representative in the whole process. That process, the children's court process, is a very informal process. So what we as lawyers and as presiding officers, magistrates usually do, we assess the age and maturity of the child, of your client. And we immediately see that this child is nervous. This child is not familiar with the circumstances of a court. And we decide what would be best. Usually we deviate from the norm to have proceedings in an open court. So we tell the child immediately, don't worry, nobody will hear what you say. You can confide in me. I'm your lawyer. I'm not even allowed to talk to your mom or your dad about this if you do not want me to. Whatever you tell me is confidential, and you can tell me that. And if you are nervous about an open court scenario, we'll do it in an office somewhere where the magistrate sits. We also normally, where the child is younger, do not wear robes, and we forsake the formalities of a system that has grown into lots and lots of heavyweight formalities, just to make it easy and comfortable for the child to be at ease when he or she speaks to the magistrate. All right. In civil, there's actually many places where we can assist a child. And I'm going to start off with something that legal aid does for many years now and does very well for thousands of children, and that is in the domain of estates. An estate practitioner in legal aid, myself being one of them, will be appointed as the executor by the master through a cooperation agreement, and we will look after, again that test, the best interest of the child. We have the duty as executor and under the Constitution then to make sure that children who stand to inherit from a father or mother who passed away, who's worked hard and saved pension monies for this child, that child's best interest be served. So we will take control of mum and dad's estate, and we will make sure that only the child benefits from this. So you can actually understand that many extended family members in an estate scenario wants to put up a monument for mum. She deserves it. We do not disagree with that at all. But we cannot spend 200,000 of the minor's maintenance money, which he will need to maybe get to matric, go to university, on a monument for mum. We have to be realistic. If someone is not in that position to look after the best interest of the child, we will have many monuments, and there will be no monies left for the child to actually look after his own well-being. In a society that is heavyweight on children, on dependent children, and where parents often die too young to raise the children themselves to maturity, we have that very important function in cooperation with the master to look after their financial and proprietary needs. Many other areas of law where we are very important is where the care and the contact of the child is of importance. Care and contact, and you as the normal public might know this and might recall this from the previous act as guardianship or custody, or one of those informal terms that were used. Custody is now phased out, and it's more specific and more understandable in the form of a care and a contact. So care would then be, who will look after my needs? Who will dress me in the morning? Who will give me food? And who will make sure that I get to school? That's the care aspect of it. Contact is, will I have the right as a child to see my dad? Will I have the right to see mum? When will I see mum? When will I have contact with my grandparents? So what we do as attorneys in this regard is we get involved either through a court order where a magistrate, say for instance, is busy with a divorce and there's a big fight about the care and contact of the children. The magistrate may rule in terms of the act that legal aid be appointed to do a report for court only on the children. So in this regard, mum has her set of lawyers if she wants, with advocates assisting her in court. Dad might have a set of lawyers with advocates assisting him in court, leaving the poor 11-year-old without a voice. So the court in these instances again refer to legal aid and say, I think this child needs a voice in court. This child needs to be able to voice his own opinion, because I, as the presiding officer, are of the opinion that the child is of the age and maturity to express his own view. And who knows better? Who knows better than the child to say what he really wants? The dilemma the child usually has in those battles between mum and dad when it comes to care and contact, if I take mum's side, obviously dad would be upset with me. If I take dad's side, obviously mum is upset with me. We call it checkmate. Doesn't matter what choice you make, you will upset one of the parties. And it's both very important to you. So what often ends up happening is that the child lies to dad and says, no, I want to be with you. And then he goes to mum and he's torn apart and he says, Mum, I want to be with you. And dad's lawyer says, the child blatantly stated to us that he wants to be with us. Now you come and you say the opposite. This leads to many, many psychological evaluations, to reports, to lots of money being spent on it. Whereas if the child is then afforded the right to have a lawyer, the attorney can say, Judge or your worship, if it's a magistrate, may I ask that the child speak to you alone in chambers, because he's got something to tell you. And he doesn't want mum there and he doesn't want dad there. He is of the age and maturity to express his wishes with you, and he wants to do it in confidentiality. The attorney can also do a report. The child can say, yes, please, deliver a report. And then I can also see what you write in the report if the child is a bit older, and we can modify that report to be exactly what I want the court to hear. So this voice that the child has is incredibly, incredibly important in modern day family law. And we have seen after the promulgation of the Children's Act that in many instances, divorces are quickly settled after the attorney is appointed for the child, because suddenly everybody is aware that there's an honest voice who's not lying to anybody and who can now express an opinion to a judge which he never before had, which is very important. Remember, this is an objective opinion, because if mum instructs a psychologist, that psychologist is under instructions of mum and is seen by the other side to be paid by mum, and therefore it is not seen as an objective report. Same with dad. If he has a child psychologist who gives an opinion to the judge, it is seen as biased because somebody is paying for it. And obviously I will not say something that I'm not paid for, which is not always true, because psychologists are above doubt and would be objective in their opinions. But it is how the parties to those proceedings see it. Legal aid is a free service. We are objective. We stand to benefit nothing from what the child wants to tell the court. So it's an objective opinion. We are not asking anybody for money. Nobody manipulates us. We do not have to consult with the mum or the dad to get an opinion. We can purely put the child's opinion before court. Again, the test under the Constitution would be, is this what I'm telling the judge in the child's best interest? And I have made the assessment of the child that he knows best. She knows best. And this is an absolute wonderful tool where Legal Aid South Africa assists children on a daily basis in children's matters in court. Obviously, we do not always have it only in care and contact matters where it's a divorce and an acrimonious divorce between mum and dad. We also have it in other scenarios, just the children's court. Maybe mum and dad was divorced many years ago, and there's a new set of dynamic circumstances that has kicked in. Mum is no longer in a position to look after the child she did in terms of a court order many years ago, and the circumstances have changed. So what we want to do now is we want to bring the matter to a magistrate in the children's court, and we want to change the formalities regarding the court orders that was previously made. A wonderful tool. Again, the magistrate will then say, well, I cannot get emotionally involved by consulting with all the parties. I'm an independent person. Let me appoint legal aid in this matter. They are available. They can do a report for me to highlight what it is that the child really wants. Remember also, it's not only a mum and a dad. The Children's Act make provision for any interested party to go to the children's court and say that I have something to provide to this child and I want the right to do that. We call it parental rights and responsibility agreements. The courts then, between mum and dad, usually assist through the legal aid attorney to draft a parental rights and responsibilities agreement. And that agreement is then made an order of court. And usually when there's a third attorney, mum's attorney, dad's attorney, legal aid attorney, when the third attorney is involved, there's an objective hand in writing that report. And even the child is mostly satisfied with it. Whereas previously he never had a choice and he had to accept what mum and dad agreed upon. Now that child has the ability to take part in the proceedings himself or herself. Children's Act basically make it possible for any interested party. I have had the experience of a magistrate children's section going as far as adopting a child cross-culturally because she felt that she had a bond with that child. And the Act makes it possible. She has no, what we call nexus or connection with the child in law. She's a magistrate, and she felt that she could play a role in that child's life because she felt the vulnerability and she was the person who could support that child. You have often grandma and grandpa that is involved with the child from birth, just after birth. Grandma takes the child from mom and dad, and then at the age of 6 or 7, mom and dad suddenly reappear and wants their children. Very few grandparents want to actually fight that battle with mom and dad, so they give up. But for the child, it feels like they lose a parent because they lose their mom in the form of a grandmother. So if you look at the interest of the child in that scenario, the child would rather want to stay with grandma, I'm very sure, than make friends with a new mother he never knew before. So in that regard, the Act opened up doors to every single person. And it also gives, a certain duty on us all. When we see a child that is in need of care and protection, we can actually step in, even if we are not the appropriate person to place the child with. We are still an interested party to take the matter further. And we can go to court on that matter, which is a very interesting development in law. So if we look at the rights that usually come under threat and that legal aid has to take care of, it is the responsibility of a father or a mother to take care of the child. Therefore, to look after that child's best well-being, to feed him, to make sure he's got money, to make sure he gets to court. Contact is important because a child cannot grow up without the other parent as a presence in his life. Sometimes the fights go so bad that dad or mum says, look, you just take the child. I don't want anything. I cannot win this battle. After 4 or 5 years I've tried. You take my child and I am out of this. We can secure that position for dad now or for mum and say that, no, you are an integral part of the child's life. The child actually has a right to you in terms of the Constitution, and you cannot just walk away at this point. Let's sit down and do this properly. So contact is very important. The other issue is guardianship. That is who will make the decisions for this child. We often bring matters to the High Court to request the court for a guardianship order. Maybe mum and dad has passed away and there's nobody to stand in as an adult to assist the child in applying for passports, in applying for different things that he needs to have. Even maybe a foster care application could be assisted with, where grandma says, I have 3 or 4 of my grandchildren living with me. I take care of them. I am their care. I am their contact. I am their maintenance. Please give me the guardianship application because I need to sign their report to school. I need to enroll them in the school. I need to be the guardian of this child. So in those scenarios, we take matters to the High Court on application and we say to court, this child really needs a guardian. Please assist us. We obviously work closely in these matters with social workers who will then assist in doing a report, both on the foster parent or the guardian, as well as the child's needs, and then would bring a report to court that suggests grandma is the appropriate person. There's a trust relationship between the child and mum. It's in the child's best interest. You can go ahead, judge, to grant this order. And it makes life so much easier for the minor child at the end of the day because he can be enrolled in school. He can go wherever he likes. He has the authority of a grandma who can sign on his behalf until he's 18 years old. Okay, that in summary gives a good overview of what legal aid does when it comes to children. All different aspects of law is impacted by the Children's Act because the magistrates, the judges, the presiding officers has a broad jurisdiction to direct that legal aid get involved. And legal aid is a valuable source of information to not only the child, not only the client, but also to the judge and the court to make an informed, objective decision at the end of the day. We therefore are thankful for the Children's Act and for the Child Justice Act to have changed the playing fields in the last 10 years completely when it comes to the law applicable to children. Just as a point of interest, just before the Child Justice Act, which would then be the act that wants to keep children out of the criminal justice system, to divert them out. Just before that act was promulgated, I myself went for a visit to a juvenile detention center at prison, and there were hundreds of minor children awaiting trial. After the act, it dropped to a handful of children because the act was so important in keeping them out of that circumstances at prison that very few children now end up before sentence, therefore as awaiting trial prisoners, in a juvenile detention center. They simply do not reach there because we look at the availability of an appropriate adult or an appropriate parent, or even a brother or a sister who has already grown up, who's maybe heading the household. Now those people can take responsibility for the child while we are awaiting the sentence or the trial to start. So it's very important, the impact of these legislations on the lives of children in this country. And you can just imagine what would have happened if that child, maybe a 13-year-old or 14-year-old, came into contact at that age with hardened criminals at prison and people who has lost their trust in life, and that just the whole negativity of life being confronted with them, to them at that early age. We don't want that, and we are very thankful that we've got the Children's Act and the Child Justice Act to steer children these days in a much better way. From Legal Aid side, thank you so much for listening to me. Thank you so much for being part of this discussion. I hope you found it insightful and something new that you learned from it. But most of all, I hope that you would actually use our services on a daily basis. Our toll-free number would then be 0800 110 110. And please call me could also be sent to 079 835 7179. We're all here available and we would like to hear from you. Thank you.